Hi, everyone. Welcome to today's live stream show. Sorry, I thought my microphone was on, but in today's show, I would like to cover two separate topics if we can get to both of them, say, in less than 40 minutes or so. There's a lot to say about each of these separate topics, and there's definitely been so many events in the news lately. I can't even keep up with them with my live streams and trying to run a law practice and everything. For example, Yale Law School has recently been sued by two former law students. And of course, there's the Travis Scott lawsuits against him. Then, of course, what we're going to talk about here first is the Kyle Rittenhouse case, and then also the situation where two of the men who had been convicted of murdering Malcolm X in the 1960s have had their convictions overturned. So I'm going to try to address that later in the latter half of today's live stream show. So a lot of stuff going on, but on a personal note, I do want to kind of brag about myself today because I'm really happy I won a motion for summary judgment earlier today in a Superior Court case in front of a former North Carolina Supreme Court justice. So that's another reason why I haven't been keeping up with all the news and everything. And if you guys have more details about what I'm going to be talking about, feel free to share that in the comments in case I missed something. So first thing is the Kyle Rittenhouse case. So I have to admit that it wasn't until about the last couple of weeks or so that I really put some energy and time into reading more of the news about it and watching more of the trial. So originally I just kind of thought like Kyle Rittenhouse was some, spoiled, conservative white kid who had gotten away with killing people at a protest. So, but then delving into it, there is a really good video. And unfortunately, I tried for the last hour to try to find this video on YouTube again, but there's an independent YouTube guy. The name was something like Matt Olafea or something like that, where he had put up a compilation of the different video footage that night when the shootings happened in Kenosha, Wisconsin. So he put that together from different people's cell phone footage to show you directly, what had happened with Kyle Rittenhouse and his victims, the people that he ended up shooting that night. So after watching that video, boy, that's where you feel like a picture or a video says 1,000 words. So in that video, you can very clearly see that Kyle Rittenhouse, although he was stupid, in my opinion, he was very stupid and immature. He looks like some, just a kid with an AR-15 prowling around the streets with a bunch of older people. I mean, that's what I find kind of pathetic is that in all the video footage that I saw, it looked like the people there protesting or rioting or whatever late at night, running around, cursing at each other and stuff. They all seem to be at least 25 years old, in their late 20s or even in their 30s or older. So it's kind of pathetic. It's like, is this what our society has come to, where grown adults or, middle-aged people are still acting like this, going around, running around in the streets, cursing at each other, trying to incite violence, just up to no good, So why was Kyle there? Why did his mom help drive him over there? Why did his friend and the friend's stepfather help him get this rifle and help him practice with it? Of course, practicing with the rifle, from what I've seen, is not illegal itself, but it's just very bizarre. And he looks so young. He has this like chubby baby face, and there he is, just running around like it's some sort of exciting movie that he's in. He was acting like a vigilante, but my overall conclusion is that he's probably not guilty. He's probably going to be found not guilty of all of these charges, because I do believe that he shot these people in self-defense after watching the video, hearing the testimony. A lot of the testimony that I did hear and read about does not help the prosecution. Even their own witnesses were saying things that it seemed like the prosecution wasn't expecting them to say. So let me look in the comments here. Like I said, feel free to let me know if there are some details that you want to bring up, because clearly I have not read 100% of every single thing on this case. So Tony, thank you for being here. Saw the judge reprimand the state for mentioning how it's the first time Rittenhouse spoke on the case, implying his right to silence was critiqued, so silence of the defendant can't be mentioned. Yes, that's correct. Yeah, so that's just like a stupid mistake, or, it's kind of baffling why the prosecutor would even make a remark about that, because he's not inexperienced and he should know better that everybody has the right to remain silent. So the prosecution cannot bring that up to the jury to insinuate that he had done something wrong because he was silent and did not immediately talk to authorities. So everybody has that Fifth Amendment right to not be a witness against himself and to stay silent. I hear in Canada, cops can keep questioning for hours after a suspect requests a lawyer or silence. In the UK, silence can be used to infer guilt. Silence looks so guilty and must feel so because they talk. Yeah, okay. So I'm not really sure what the law is in other countries, but definitely here in the US, once a person says that they want an attorney, they don't want to talk anymore, they request to leave, then they are not supposed to be just like trapped there in a small room to be hounded. So yeah, definitely that's like a basic right of the criminally accused in the United States. But in civil cases, apparently not giving discovery or being silent can be used to infer wrongdoing. Yeah, that's right. So civil cases, it's totally different. So I don't know if you guys have seen my live stream shows about Robert One, who was an attorney that was murdered in DC back in 2006. But he was a friend of mine, so that's why I've done multiple shows trying to bring his murder some attention. But in that case, definitely, in the civil case, the defendants continuously refused to answer any questions at depositions and kept pleading the fifth. So in the civil case, definitely the fact finder can infer that, perhaps the person is guilty, when they don't respond or they won't respond to questions in civil cases. So that can be brought up, but not in criminal cases. Yeah. Okay. Thank you. Let's see. Yeah, in front of a prestigious judge. Yeah, I mean, it was almost a slam dunk type of case against a pro se litigant, but hey, a win is a win, right? Okay, we'll just see if there's an appeal coming down. Yeah, okay, so I definitely did read about that, about how Kyle is now a nursing student, and he seems to have a passion for caring for the weak. Juxtapose that against a brute with the AR-15. Yeah, I mean, I just, from everything that I've seen and read about him, it does seem like he's like this guy that really wants to be the hero. He wants to be in there in the mix. He likes to be in there to so-called, save the day or act like a hero or whatever. I mean, it seems very foolish and foolhardy to me. But, the fact that he was working as a lifeguard and he had done some sort of like training program with the police department, or, maybe he was trying to study to be an EMT. So the guy likes that rush of adrenaline and rushing in and saving the day and stuff. And so that was his, like, I guess, sort of a personality flaw that caused him to be in this kind of dangerous, ridiculously dangerous situation. I mean, it always... when I was watching that video earlier today, and I'm really annoyed that I can't find that video on YouTube again because it was so well edited and it got like hundreds of thousands of views. But when I saw that video again, I thought, wow, for that kid, he still looks like a kid. It probably felt like he was in some movie or in a video game or something. And of course, we have at least one or two generations of people now who have grown up playing all these violent video games, watching violent movies and stuff. So he probably just thought it was so exciting, to bring some thrill in his life, to have that big rifle and run around at night, in the thick of things, and think that he was like protecting society and protecting businesses. Yeah. So that's kind of a sad reflection on society and young people in general. Right. So, hi, Ms. Sonia Elaine. Thank you for being here. Yeah, the law is clearly more about process than justice. Yeah, I mean, there's just like so many procedural things. And as you know, sometimes criminally accused people or convicts get off on some sort of criminal procedural error too. So, okay, so getting back to the Robert Wone case, his roommates. Oh, okay. Yeah, they weren't his roommates, but he was actually there just spending a night because he had been working late in DC. So he went over there because one of the homeowners was one of his best friends from college. And so that best friend was a gay man who was um, living there with his married male partner, as well as this third guy that was sort of like part of their trouble. So they weren't Robert's roommates, but that's a whole nother issue. So if anyone's interested in hearing about that Robert Wone murder mystery and everything that happened, please feel free to watch my other live streams about that. Yeah, thank you. Okay, great. Yeah, I mean, it's been all over the news. And I know, people might wonder, why don't you cover some of the other things in the news, like the Ahmaud Aubrey case? That's another thing that I would like to cover when I have time, but I'm actually going on vacation this weekend too, and next week is Thanksgiving. But eventually, I hope to also have a live stream show about the Arbery case. Yeah. Yeah, exactly. Yeah. So they can't just, you know, smear, Kyle Rittenhouse as being some brute racist, make America great again person that went there to try to shoot protesters or whatever. In fact, the people that he did shoot, one of them is a pedophile who had just gotten out of a mental institution and had been off his medicines for at least 7 to 10 days. Yeah. Do you think the defense has grounds for mistrial given the doctored video that the state didn't provide the defense? Okay, well, from what I did read about that, I think the state did provide them the video, except the video that the defense got was a fuzzier version of the video. So I'm not sure. Yeah, but I mean, I kind of feel a little confident that he's going to be found not guilty on all the counts anyway. So we'll see. I mean, otherwise, of course, everybody would ask for a mistrial anyway. So let's see. Oh, I'm sorry to hear that. Is that really true? Okay. Yeah, I used to watch Who's the Boss all the time. Okay. But we're talking about the Rittenhouse case for now. Yeah. Um, oh, okay. Yeah. Thank you for the breaking news. I'm sorry to hear about that if that happened to Tony Danza. Yeah, I did really like him back in the 80s, right? So, okay. So Alfred Adler called it the masculine protest in males over compensation. There are also types that impersonate cops. Yeah, yeah. So hopefully Kyle will at least learn this lesson to go and live the rest of your life peacefully. Just stay away from these kinds of, protests, riots, gatherings at late at night when people are there just to be causing trouble and lighting things on fire and attacking people. So yeah, I mean, if I had a teenage son or had any child that seemed a little bit more inclined to running towards the action like Kyle did, I would definitely tell them, are you kidding me? Stay home. There is no need for you to go out there and act like act like law enforcement or try to play the hero or whatever. Just stay home and stay safe, right? As my friend's father would say, there's no need to be outside after 11 p.m. because nothing good ever happens after 11 p.m. Yeah. So what about the jurors? Apparently a journalist followed the jury bus. Yeah, yeah. I did read an article about that just a little while ago this evening. Yeah, so I do feel sorry for the jurors. I mean, people who are jurors on these high profile criminal cases, you always feel sorry for them. And see, unfortunately this is why so many people want to get out of jury duty, which I think is terrible, because we need to make sure that our criminal justice system is fair and that the criminally accused are being judged by a jury of their peers, just not a bunch of, jobless people that couldn't come up with a good excuse to get out of jury duty. Yeah, but on the other hand, if the poor jurors feel like they're being harassed or could be targeted later, then of course, that's unfairly prejudicial to the defendant, to intimidate jurors, or even though I think that journalists claimed that I think it was a man, was not planning on talking to any of the jurors, then what are you doing, following around the bus then? Like, that's got to just be some slight form of intimidation, even if you don't mean to intimidate them or to actually get out of the car and start yelling at them or take pictures or whatever. Yeah, I mean, leave the jurors alone. Yeah, we need to maintain the integrity of our criminal justice system, right? Yeah. What are the limitations? Do they get free food? Yeah, I think so. I mean, I don't know about every state and how they do it, but just based on my experience in federal court as well as state court, the jurors typically either get food brought in, or they are given a per diem, like a daily amount to cover sort of like the cost of their lunches. So I seem to vaguely remember when I interned for a federal judge in Maryland a long time ago, they were given menus for some local restaurants, and then the food was brought in directly to them inside the courthouse. Yeah, but other limitations. I mean, like, I know this because I was actually summoned for jury duty twice for state court in the last year and a half, and once for federal court. And I don't know why. I mean, all these years, I always thought that wouldn't it be great to be on a jury? I would love to be on a jury, because I think I'm a fair person. I want to listen to something interesting, like an interesting trial, and be able to throw in my 2 cents or have some impact on somebody's big legal case. But I don't know why it is, after all these years, the only time I got called for jury duty 3 times was after COVID hit. And there was no way in heck I wanted to be sitting around in a courtroom with a ton of other people, all breathing the same air and stuff. Yeah, but I got out of jury duty all 3 times because they always seem to coincide on days that I already have my own court hearing scheduled. So I always had to fill out the form and explain why, and then the judge would excuse me. Yeah. So the jurors, definitely, it's an impediment to getting a good jury, because people are going to have to miss work if they are gainfully employed. So if you really want a jury full of educated people, then I don't know. I mean, maybe the jurors should get paid more or something. I mean, you're not supposed to be able to be fired from your job, but if you're an hourly employee or if you're self-employed, then it's just really hard for somebody to be on a jury, because that means you're not going to get paid for that time that you could be stuck in the courthouse for a week or a couple of weeks. It could be even longer. Yeah. So that's just kind of like the downside, the problem of trying to get a good jury, is that most people try to get out of jury duty when they have real jobs and other obligations. Yeah, they were well fed. Protesters outside the courthouse are probably scaring them. Both sides seem rowdy. Yeah, I mean, people just need to mind their own business and stay home and let the justice system play out. Going out there protesting and yelling and, trying to intimidate the jurors, that's not going to get anywhere. I mean, what a waste of effort. People need to get a life, Plus, aren't they still concerned about COVID risks? So, yeah, I think it might be fun too. On the other hand, you could wind up being a juror on a really boring case, like about, commercial real estate contract or whatever, And then on the other hand, even if it might be an interesting criminal trial, I think some people might also be intimidated, because then they would think like, great, now I have to show my face in the courtroom, and, this criminal defendant and all his family and friends, know who I am, or they can figure out who I am, and I'm scared. You just never know. I mean, yeah, I think it would be, personally, I think it would be interesting too. But if I really did get on a jury, I would probably be kind of annoyed also, because I'm self-employed. So I got plenty of work to do. And if I'm not working, that means I don't make any money, but I still have bills to pay. Yeah. I was on a mock jury once, they pay you. So yeah, exactly. Yeah. I know some attorneys that would do things like that too. Yeah. But then again, you also wonder, are the people that I'm paying to be on this mock jury, are they going to like really tell me the truth about how they would really feel, or are they going to tell me things because they, want to curry favor with me or want to be selected more for this kind of work? I'm not sure. Yeah, but it's an interesting thing you can do to make extra money. How can jurors be disqualified during jury selection during a trial? Yeah, I definitely heard about that too. Yeah, I mean, okay, so I don't do criminal defense, so my knowledge may be quite rusty or even incorrect because things can be different from state to state. But normally, each side already has a number of strikes that you can use without having to give really a reason to just knock off some jurors. And then you can also ask each potential jury member questions to try to figure out if they might have unfair biases against your client or your side of the case. And then you can also ask that the person be dismissed for cause. So that all happens during the jury selection. Yeah, because my only experience with that was in a civil trial that I did. And I remember writing down the names of all the people that were, you know, possibly going to be on the jury. And then that night I went home and Googled every single one of them and looked up their voter registration records and everything. So anyway, yeah, definitely each side will be doing some thorough research on the people to decide who they want to knock off the jury and who they want to keep, who they think might be more sympathetic to their client. Yeah, and I did hear that the defense hired a jury, what do you call it, like a jury consultant, the same person that might have worked on the O.J. Simpson case, to try to profile, it's all about stereotypes, right? Try to profile the different jury members and see, who might be better for the defense compared to some other people. So, so getting back to the Rittenhouse case, though, I do want to share this really interesting article that I found today written by a GW, George Washington University law school professor, and his name is Jonathan Turley. So this was written pretty recently. Hope you guys can see that, right? Okay, so this is on thehill.com, and Professor Turley is pretty famous because he's always being asked to commentate on things in the news and, writes articles and stuff. I definitely remember hearing about him back when I used to live in DC and went to law school at Georgetown. So it says the Rittenhouse Trial Perils of Weighing Public Opinion Over Evidence by Jonathan Turley, opinion contributor, November 13th. So this is very well written. I really like this essay. He wrote, with closing arguments scheduled for Monday in the Kyle Rittenhouse trial, the jury will soon get one of the most politically and emotionally charged cases in history. The question, however, is whether the prosecutors practically closed this case before it began in 2020. They followed a long pattern of prosecutors rushing indictments and overcharging defendants in high-profile cases. Even with the court agreeing to a key favorable instruction, the prosecution may have doomed this case by responding to the weight of public opinion rather than to the weight of the evidence. Rittenhouse fatally shot Joseph Rosenbaum, 36, and Anthony Huber, 26, on August 25, 2020, during rioting in Kenosha, Wisconsin, following a fatal police shooting. He also wounded Gage Groswitz, I think that's how everybody was pronouncing his last name, 27. The still photos of Rittenhouse walking on a street with an AR-15 rifle strapped to his back triggered widespread outrage. Then presidential candidate Joe Biden labeled Rittenhouse a white supremacist in a tweet showing his photo and demanded to know why then President Trump did not disavow white supremacists. Prosecutors sought to quell the public outrage by charging Rittenhouse, 17, on August 28th. He was charged as an adult with first-degree intentional homicide, first-degree reckless homicide, first-degree attempted intentional homicide, and 2 counts of first-degree reckless endangerment. While charged as an adult on the murder counts, he also was charged with possessing a weapon while under the age of 18. What is most striking about the trial is that even more than a year later, prosecutors seem to be learning critical details at the same time as a jury. A strikingly different image of the victims and shootings quickly emerged. There also were glaring prosecution blunders, including a potentially case-ending violation of a court order and longstanding constitutional law in using Rittenhouse's post-arrest silence against him. Judge Bruce Schroeder was criticized for telling prosecutors that, like many judges, he objects to using the term victim when the jury has not ruled in the case. The trial seemed to bear out that judgment. From the outset, Rosenbaum, 36, was portrayed as a menacing, violent actor. A convicted child molester, he was described by various witnesses as threatening Rittenhouse and others and engaging in random violence. At one point, Rosenbaum pushed a burning dumpster into a police cruiser with officers inside. Prosecutors tried to rehabilitate him with disastrous results. They called Richard McGinnis. So I definitely saw the footage of this. So it really did not help the prosecution. A journalist who was next to Rittenhouse when he shot Rosenbaum. One prosecutor confronted McGinnis and declared, "You have no idea what Mr. Rosenbaum was thinking at any point of his life. You have never been inside his head. You never met him before." McGinnis shrugged and said he, quote, never exchanged. Oh, gosh. What happened to this? Sorry about this. There are ads that keep showing up over here. He never exchanged words with him, if that's what your question is. The prosecutor then pressed further, saying McGinnis had no idea what Rosenbaum was thinking because it, quote, is complete guesswork, isn't it? Unquote. McGinnis dryly responded, well, he said F-U-C-K, you, and reached for Rittenhouse's weapon. Okay, so that definitely did not help. Witnesses described Rosenbaum as brandishing a chain and threatening to kill others. Okay, I hope you guys can still hear me, right? Okay, I'm just kind of switching back and forth here between the news article versus seeing what's going on StreamYard. Prosecutors then asked Rosenbaum's girlfriend, Carrie Ann Swart, if he had taken medication earlier on the day he was shot. That opened a door for the defense to ask Swart what the medication was for, and she revealed that Rosenbaum suffered from bipolar disorder and depression. Yeah, and it also sounds like he was under a protective order that she had fought and gotten against him, so he was supposed to be staying away from his fiancée/girlfriend. Grosswitz fared little better. He admitted under cross-examination that Rittenhouse did not shoot him when he had his hands up after a confrontation. Instead, he admitted Rittenhouse shot only after Grosswitz pointed his own 9mm handgun at Rittenhouse's head. Okay, so that definitely supports the defense saying that Kyle was just trying to defend himself. The jury heard how Rittenhouse was chased as Huber struck him repeatedly with a skateboard and someone else hit him in the head with a rock. I heard that when Kyle Rittenhouse was hit in the head with a rock, he was hit so hard that his body spun around almost 180 degrees on the ground. So it's amazing that he did not get, totally messed up with the need for ongoing medical treatment, or he could have died himself. Even the prosecution's medical witness proved beneficial to the defense after he admitted forensic evidence would support claims that Rosenbaum was grabbing the barrel of Rittenhouse's rifle when he fired. One prosecution witness, photographer Nathan DeBruin, caused a stir when he accused prosecutors of pressuring him to change his statement on what occurred that night. Assistant District Attorney James Cross reviewed DeBruin's account and asked oddly, "We didn't ask you to change it." To which DeBruin said, "Yes, you did." Okay, so that did not bode well either. Given the weak prosecution case, it would have been tempting not to put Rittenhouse on the stand. However, the defense clearly believed it had passed the line for a hung jury and was wanting to push for an outright acquittal. Rittenhouse described how he spent the day cleaning off graffiti from the high school and how he was asked by a business owner to protect his building. Well, it's kind of weird. Why would the business owner be asking teenagers to protect his building? Weird. Okay. He also described how he brought a medical kit and gave aid to people injured during the rioting. Okay. For those watching the trial, there was a shocking disconnect from prior news coverage and the actual evidence. There was an even greater disconnect with the charges. Okay. So, anyway, towards the end, the professor wrote, even with some lesser included offenses, it will be hard for prosecutors in the Rittenhouse case to make this cat walk backward. They promised the jury that it would see a vigilante rampaging in utter disregard of human life. Instead, the jury saw a much more confusing, chaotic scene in which Rittenhouse was threatened with a gun, hit repeatedly, and chased down a street. On Friday, prosecutors pushed to add lesser charges. The defense waived objections to the consideration of lesser counts on some but not all of the charges. While allowing such consideration, the judge pushed back on considering a lesser charge of second-degree reckless homicide because that would not require proof that the teen exhibited an utter regard for human life. Okay, so anyway, it says, absent a prosecution saved the Rittenhouse case may prove yet again how a prosecutor satisfying public outcry can wind up sacrificing a criminal case. Jonathan Turley is the Shapiro Professor of Public Interest Law at George Washington University. Okay, so this I find very well written, and since it's written by a law professor, you know that he has very carefully researched that whole case. So thank you to Professor Turley for that essay. Let me come back over here again to take a look at the comments. Yeah, thank you guys for being here again. Yeah, Rosenbaum could have stopped running it. Yeah, exactly. I mean, what I saw in the video, I mean, Kyle Rittenhouse was trying to get away. He was just running and running 2 blocks. I mean, sure, he's holding a rifle, which enraged a lot of people, but he wasn't shooting people. He was being chased by Rosenbaum, and Rosenbaum threw the bag with stuff in it at him from behind. And Rittenhouse thought that, what did he think it was? He thought it could have been a chain or something. I mean, he didn't know what was in the bag, or that it was even a bag. Yeah, and then from what I saw, it looked like Rittenhouse did get kind of like backed up or cornered in between some cars and stuff. You know, you can't really see it very well from what video I saw, but it was not just some sort of slam dunk case where Kyle went up to Rosenbaum and then just shot him out of the blue. He was definitely being chased and cornered into a spot between some cars or something. So McGinnis made the defenses. Yeah, totally. Oh, okay. Yeah, thank you. I'm glad that works. I mean, sometimes I have these live streams and there's some audio problem where turns out nobody could hear me when I switched over to a different screen. Yeah. Oh, thank you, Debt-Free Dad. Thanks for being here. Yeah, okay. Yeah, I remember reading that he was in the mental hospital up until that day. That's why he still had that hospital bag with his stuff to throw at Kyle. So, yeah, exactly. The Broom was brave standing up to Cross like that. I think they thought he was a pushover because of his speech impediment. Oh, okay. Yeah, I didn't actually hear the video. I just read about it, so I didn't know he had a speech impediment. Yeah. So anyway, just that's just my opinion there. You know, maybe we can watch a tiny bit of another video that I found on YouTube where they do show video footage of what was going on that night.
The armed men appear emboldened by the inaction of the police towards them. Minutes after encountering the officers, Rittenhouse explains
to
a reporter from the Daily Caller why he thinks he belongs in Kenosha.
Our job is to protect his business, and part of my job is also helping. If there's somebody hurt, I'm running into harm's way. That's why I'm my refuge.
It's about 15 minutes until he'll fire his first shot.
Okay, so he just looks like he's a little bit too excited to be there.
Are now close to each other. And the situation is about to turn deadly.
People just crammed up in
Nathan
there.
P. is filming from here. Hannah Giddings and her boyfriend Anthony Huber are nearby. Corey Washington is here. His footage captures both Gage Grosskreutz and Ryan Balch walking by. Then Kyle Rittenhouse runs past his camera.
I've been looking kind of at him the entire time because he looked young, he had a gun. So at the point where I see him run by me, I was like, that's weird. So I followed down in that direction.
Okay, so that's one of the guys that was recording him.
Rittenhouse walks towards a parking lot where cars are being vandalized.
There's Rittenhouse.
He passes Joseph Rosenbaum,
There's
who was fighting with the
Rosenbaum.
armed men at the gas station earlier. Rosenbaum now starts chasing Rittenhouse.
Yeah.
And throws a plastic bag that holds his belongings from the
Okay,
hospital.
he throws the plastic
Close
bag
behind
at
him, a man
him,
holds up a handgun and fires it.
and
We don't know
the
why.
other guy starts
Then Rosenbaum
shooting.
lunges towards Rittenhouse.
Oh, now I can't
Rittenhouse
remember
fires
his
4
name
times.
now. Something like
And I've been in his
Zimlicki
shoes,
or
getting
something.
chased, and then I heard a gunshot. I can't say that I would have done anything differently.
Rosenbaum, who's been hit, falls to the ground. There are 3 more shots from someone else in the parking lot.
Oh shit. We got shots fired, guys. We got shots fired. Pop, 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 pop. And I was like, oh, so they are really shooting. I gotta find some cover. Oh,
Okay,
man,
so
maybe
that's where the
they
guy
are
recording
really
the video
strong to kill
decides to
people.
run
And if
for
they were going
cover.
to take
Yeah,
advantage
good
of the
idea.
situation, I'm a black person, and I don't want to be a target.
Rittenhouse calls a friend, while others are helping Rosenbaum, who's on the ground.
So Rittenhouse
Then he
calls
flees
his
the scene.
friend and flees the scene.
He didn't disarm himself after his first shooting. He continued to run around. As a gun
He
owner, I
started-
view his actions as
He
completely
was
irresponsible.
running
Come around
around,
through looking
acting
wild with a gun on you.
irresponsible.
People are going to think that you're doing something wild with a gun on you. So they reacted the way they should have reacted.
As soon as they were all saying he shot somebody, Anthony was gone. And I tried to grab onto him and like nobody was gonna stop him, you know? And then I hear a bunch more gunshots down the road and I was like, I just had a feeling. I just had a feeling it was him.
Rittenhouse trips and falls.
Okay, that's when
Anthony
he
Huber
trips
hits
and
Rittenhouse with
falls.
a skateboard and attempts
So-
to disarm him.
And the
Rittenhouse
guy
shoots him in
starts
the
hitting
chest.
him with a
Here is Gage Grosskreutz with
skateboard,
his gun drawn.
and then
He also gets shot and calls
Grosswitz
out for
comes towards him.
Reality
Okay.
of it is this is
All right. Yeah. So definitely there's plenty of YouTube channels and news websites where you can see video of this yourself. But, you know, once he shoots Rosenbaum, then he starts running and then falls on the ground. You know, all that stuff happens so quickly that, and given the witnesses' statements and everything, I do think that, you know, probably the majority of the jurors are going to be convinced that Kyle Rittenhouse did that all in self-defense. Yeah. Oh, Zeminski. Okay. Thank you, Super K Pill. Yeah. Thanks for the name of that person that was also with Rosenbaum, and Zeminski was the one that first fired some shots in the air when Kyle was running away. Yeah. Okay. Look at Rittenhouse's demeanor. Does he seem like he's there to agitate or cause trouble? Yeah. Yeah. I mean, yeah, it didn't seem like he was just there to cause trouble. You know, he was, well, he was lying, but he was telling people that he was an EMT and he wanted to help. You know, he helped somebody who had gotten shot in the foot or something. You know, somebody had gotten hurt, and so he did something to sort of help the person, or maybe put a Band-Aid on another person. Yeah. So it's, like I said, it's still disturbing though. Like he looks so young, and what's he doing out there with AR-15? You know, he should have just stayed at home, right? I mean, hindsight is 2020, right? I bet his mom wishes that she had just like told him just sit his butt down at home and don't be going out there at night. Huber's girlfriend said she feels sorry for Kyle recently. She said she doesn't think he had ill intent. Oh, okay. Interesting. Okay. Yeah. Thank you for the information. Yeah. So I get the feeling that a lot of people, you know, probably have already read tons of the articles about this case, and you can watch all the amazing closing arguments and stuff. So I did watch some of the defense closing arguments this evening right before the live stream, and I was thinking, wow, this Mark, what's his name again? Mark Richards. Mark Richards is the lead defense attorney for Kyle Rittenhouse. And I was thinking, wow, he's a great attorney. I wish I could argue like that and have such ease in front of a jury or ease in front of a judge, and to have that confidence. And if I were ever accused of a crime, certainly I would want a defense attorney like that guy, Mark Richards. So let's look into him and critique him as an attorney. Why don't we? So let's see. So I found his website. Okay, so his website is Racine. Is that how you pronounce it? Yeah. Okay, racinedefense.com. Richards and Dimmer, SC, criminal defense attorneys. Okay, so their website looks very nice and professional. Free consultation. Okay, so typically the criminal defense attorneys do offer free consultations since 1987. Mark D. Richards. He's been practicing for over 30 years now, providing quality representation. Oh, there's a typo on his website. As a criminal defense attorney, he practices as a homicide attorney, a drug charge lawyer, a sexual assault attorney, burglary and theft attorney, domestic violence attorney, and a white collar crime attorney. Okay, so that's kind of poorly written, but I get the feeling that the person that did his website had to keep putting in attorney to get it to show up more on search engines. Okay, so yeah, so he's a pretty good attorney. I think he's done a great job for his client. I was very impressed with his presentation and the closing argument that he gave. It says, no case is too big or too small. I've tried over 100 jury trials, ranging from simple 2-day operating while intoxicated trials to month-long homicide or drug conspiracy trials. Wow, that's amazing. Yeah, because the truth is that most attorneys, unless you do criminal law, criminal defense, either or if you work as a prosecutor or a public defender, you know, those are the types of attorneys that are constantly in court and doing jury trials. But for civil litigation attorneys like myself, it is very, very rare for us to get jury trials. In fact, some of the older attorneys even say that they're looking for cases to get involved in where they might have jury experience, because getting to jury trial is very rare in civil cases. Most cases will settle if they have any merit, or sometimes after you start handling somebody's case, you realize the case really isn't as good, or the client was exaggerating or whatever, and so you either try to settle the case or get out of the case. So that's why if you really would like to do trials and you really want jury experience, then definitely go into criminal law instead. So this guy, Attorney Richards, went to University of Wisconsin-Madison for his undergrad as well as law school. So that's great. He graduated in 1987. And so it looks like he started out his career probably working at a small law firm, and then moved into the district attorney's office in a couple of different counties. Then he had his own practice and became partner at Richards and Hall. Then he had his own practice again, and now he's in practice with another law partner. So yeah, so very impressive. And that's the way it should be, right? Because if you're facing a very lengthy prison sentence, then you definitely want someone that is very experienced. And I don't know how Rittenhouse's family is able to pay for this guy, but good for him for getting such great representation. So I am really impressed. Yeah. So let's move on then. Okay. Horrible 6 weeks. Well, I feel sorry for the jury, the poor people that had to serve on the jury for 6 weeks. I mean, 6 weeks out of their lives. And then like in the OJ trial, the jury had to live in a hotel. They couldn't even be back with their family for quite a long time. So yeah, it's a very big burden on people to serve on a jury. Yeah. What are your thoughts on Binger? Is that how you pronounce it? Binger, I think so. Yeah, I mean, poor guy. I mean, we don't know what's going on behind the scenes, because normally the prosecutors should be very well versed in what the witnesses are going to say. So they probably just didn't have enough resources. They're usually people in the DA's offices are overworked and underpaid. So they don't have enough support staff. It's not like some posh firm where people are making tons of money. So, yeah, so we can't, I mean, I don't really want to say anything negative about the prosecutor, the main prosecutor, because we don't know what's going on. Yeah, I mean, it's probably not really a reflection on him being a crappy attorney, because he's given the facts as they are. And of course, every attorney knows that sometimes you put a witness up on the stand and they don't say what they told you before. Sometimes witnesses forget things, or they change their stories, so we can't really just like say, oh, he must be a crappy attorney. Look at this crappy case and stuff, because there's probably plenty of other people that had a role in, what Kyle Rittenhouse was going to be charged with, and, what witnesses they were going to call. I mean, yeah, it definitely would have been better if he had been better prepared on what the witnesses were going to say, though. Yeah, because you never want to ask one question too many, as what happened here with the prosecution, where the witnesses just kind of started saying stuff that was good for the defense. Yeah. So, yeah, 6 weeks is a long time. He seems really corrupt. Yeah, I don't know too much about him. Yeah. Why was Kyle so slow at not shooting people? Yeah, I think he just enjoyed it. I think he was just kind of giddy at first, to just walking around with a rifle. It was his way of like seeming important that night. Yeah, to him, it was like probably like a pretty cool power trip, to be in the middle of all this excitement. And, it probably brought some excitement to the monotony of his normal life being a swimming pool lifeguard. Yeah. So, yeah, look what happened there. Now he's facing potential, multiple decades in prison if he gets convicted. Yeah. Oh, okay. Okay. So thanks for that information. Yeah. Oh, hi, Em. Thank you for being here also. Okay. So, all right. So let's, oh, shoot. Well, I did want to mention another article about Rittenhouse case, but that's okay. Let's move on to Malcolm X then. So I took an interest in this case involving the murder of Malcolm X because I was an ethnic studies major at UC Berkeley, and during freshman year, we all were assigned to read the autobiography of Malcolm X, which is actually one of the best books that I've read. I mean, I really don't have time to read many books anymore now that I'm so busy working all the time and stuff. But this was like a very powerful book that I read freshman year during winter break from UC Berkeley. And so it was kind of a surprise to suddenly hear in the news again after so many decades. You know, Malcolm X died in the mid 1960s. He was shot at the Audubon Ballroom in Harlem while he was giving a speech. And you know, his widow was there. He left behind 6 children. And just to kind of tie this in personally, when I was living in San Francisco after graduating from Berkeley, I did some volunteer work at the Asian Law Caucus. And one of the people working there was Audie Kochiyama Holman, who is the daughter of the Japanese American activist. I have a poster of her here, Yuri Kochiyama. So Yuri Kochiyama was a Japanese American woman who had been interned during World War II. And she and her husband and her family ended up living in Harlem, also in New York City. So Audie and her family, I'm not sure exactly how, but they were friends with Malcolm X and his family. And so I always thought that was really cool. Like, I didn't talk to Audie a lot about her family's relationship with Malcolm X's family. But in 1998, when I went on a trip to New York City, I was able to go up to Harlem and visited with Yuri Kochiyama in her apartment there, or her condo. And again, I do wish that I had been able to spend more time with her and ask her more about her relationship with Malcolm X. But Yuri Kochiyama was the Asian American woman who is in a lot of pictures where she is kind of holding on to Malcolm X as he lay dying on the floor that day at the Audubon Ballroom. So that's kind of like my tangential relationship to this, you know, having met and known somebody who was friends with him. Yeah. So let's move on over here. Oh, okay. The other article, it was just like a AP News article where there were a couple of attorneys that gave their thoughts on which side did better, the prosecution or the defense. And I mean, it was just a very quick article too. And I didn't really agree with some of that legal analysis or whatever, but it was a very short article about which side did better. So, okay. So let's look on over here to the New York Times article about the news regarding the overturning of the convictions of 2 men who were accused and convicted of killing Malcolm X. Okay, so in this is a New York Times article. It says 2 men are exonerated in Malcolm X killing after travesty of justice. I do not need this court, these prosecutors, or a piece of paper to tell me I am innocent, said Muhammad Aziz, who spent 2 decades in prison. Yeah, so out of the 3 men that were convicted of killing Malcolm X, only one of them is still alive, and that's Mr. Aziz, who I think is about 85 years old now. And this article says, a judge tossed out the convictions of Muhammad A. Aziz and Khalil Islam, who were found guilty of killing Malcolm X. Mr. Aziz spoke about the travesty of justice at a court hearing. Okay, so that's great that he's still alive, and, you know, that he got out of prison, I think, in 1985, but there was always that cloud of suspicion and, you know, people not wanting to be associated with him because of what he had been convicted of. So it says, here's what you need to know. One of Malcolm X's daughters says she hopes the full truth can come to light. J. Edgar Hoover hid that some witnesses to Malcolm X's murder were FBI informants. 5 things to know about the exonerations. The exonerations leave larger questions unanswered. The prosecution's case was weak. Still, the jury chose to convict. Yeah, but that was back in what, like maybe around 1966. So things have really, really changed since then, we would hope. But yeah, there's just like so many like screwed up things that really happened back then, and some would say still continue to happen these days regarding the rights of the criminally accused. So this is a picture of the Manhattan District Attorney Cyrus Vance, who agreed to look into the men's convictions. I think it was last year when Netflix released a new documentary about who killed Malcolm X. So I looked a little bit into this attorney, Cyrus Vance, and I was very happy to find out that he also graduated from Georgetown Law School, which is the law school that I went to. So it just goes to show how important it is to get good people who are fair-minded and, have an open mind to be in charge in all these different arenas, whether it's in law enforcement or in the prosecutor's office, judges. So it really was thanks in part to this attorney, the district attorney, Cyrus Vance, who agreed to revisit this case and look into the evidence against these men that did get convicted so many decades ago in the murder of Malcolm X. Yeah, so let's take a look here. Okay. I will share the wiki here. Okay, so Cyrus Vance Jr., born 1954. He's an American attorney and politician serving as the District Attorney of New York County, New York, also known as the Manhattan District Attorney. He was previously a principal partner at the law firm of Morvillo, Abramowitz, Grand Yason, Anello, and Borough, PC. So he's the son of Cyrus Vance Sr., the former Secretary of State under President Jimmy Carter. So I didn't know anything about this man until I just Googled him recently. So it seems like he came from a very prominent family, and where did he go to for undergrad? Okay. So it looks like he went to private schools and then went to Yale University and then got his JD from Georgetown University Law Center in 1982. While in law school, he planned campaign trips for Colorado Senator Gary Hart. Yeah. So I guess, the takeaway from this is that, a lot of times people who do reach these high positions, they've grown up in privileged circles and they have the connections. And that's why for some people whose families might not be as well off and educated, it becomes even more important to try to go to these top-notch schools so you can make your connections and network with people, right? Yeah. So anyway, yeah, glad to hear that Cyrus Vance also went to Georgetown for law school. And then also the attorneys that represented the family or represented Muhammad Aziz, that I find pretty interesting too. I wonder how did these attorneys even get in touch with Mr. Aziz and then agree to represent him? Because, most likely, I'm just assuming that he and his family probably didn't have money to pay an attorney, but yet this small civil rights boutique firm in Manhattan took on the case and really did a lot of research, as well as the men that made the Who Killed Malcolm X documentary. So that's pretty amazing how all these things had to come together to clear the names of these two people, one of whom has already passed away. So the attorney that represents Mr. Aziz is this guy here, David B. Shanies, who looks like he was a partner, or he worked at a bigger law firm for a while. He also clerked for a district court judge, federal judge in New York. So really smart guy. He went to NYU, which again is a very top law school nationally. Graduated from New York University Law School in 2006. He had gone to Vassar College for undergrad. So very smart guy, very well educated. And so I do wonder, how was he able to start his own boutique law firm? Clearly you definitely need to have a lot of money to have an office in Manhattan, and then to be able to do this high stakes litigation. A lot of it is probably done on a contingency fee. You definitely need to have a war chest to do that. And I also checked out one of the other attorneys from his firm who worked on the case. And both of the other attorneys here, Morgan Miller and Deborah Francois, They also worked for big law firms first before they switched over to working here at Shaney'sLaw.com. So Deborah Francois just started working for Mr. Shaney's last year. And she went to Yale Law School, graduated in 2014. For undergrad, she went to Hunter College. She was also a law clerk for Judge Daniels, U.S. District Court for Southern District of New York. Yeah, so pretty impressive. Yeah, this is really amazing that this is the firm that was able to help represent Muhammad Aziz and clear his name. Yeah. So the associate there went to Cornell Law School, graduated just a couple of years ago. She has a master's degree also from Columbia and went to Vanderbilt University for undergrad. Yeah, wow, editor of the Cornell Law Review. Wow. So it looks like she worked as an associate for this big law firm for a while in litigation, but probably left within a year or so. But good for her getting a very interesting, prestigious job at this other firm also. So that's pretty amazing. Yeah. So yeah, just wanted to mention this news about the Malcolm X murder. And it says here that crucial evidence was withheld during the men's trial. The 43-page motion, which was granted at a hearing on Thursday, described in detail the investigation conducted by the district attorney Cyrus R. Vance Jr. and the men's lawyers. It concludes that if evidence withheld by the Federal Bureau of Investigation and the New York Police Department had been given to the defense, the trial would have gone differently. These defendants did not receive a fair trial, the motion says, and we respectfully submit that their conviction should be vacated and the indictment against them be dismissed. The new motion includes a host of new findings. It mentions an interview with a new witness, J.M., conducted only days after the reinvestigation began. J.M. said he was answering the telephone at the Nation of Islam's Harlem Mosque the day of the assassination, and that his account backed up the alibi of Mr. Aziz. J.M. recalled receiving a phone call from Aziz at around 3 p.m. on February 21st, informing him that Aziz had just heard Malcolm X had been shot, the motion says. J.M. then hung up and went to get the mosque captain, and together the two men called Mr. Aziz back at home. J.M. reached Aziz at home and told him the captain wanted to speak to him, the motion says, a simple sentence that lends credence to Mr. Aziz's story that he was at home at 3 p.m. when Malcolm X was shot. The motion details more than a dozen reports compiled by the FBI and the New York Police Department that were not disclosed to the defense, several of which point to the men's innocence. The FBI reports contain the accounts of several witnesses who described gunmen who do not resemble the two men, as well as details about agency informants who were present in the Washington Heights ballroom where Malcolm X was killed. One FBI report from September 28th, 1965, even contains a description of the man whom some experts on the assassination have concluded was probably the assassin who wielded a shotgun, William Bradley. That report gives a description of Mr. Bradley, who was 27 years old at the time, and matches the one given by a defense witness of the shooter who had a shotgun. He had been a lieutenant in the Newark Mosque and was known as a strong man there, the FBI report on Mr. Bradley said. He was a machine gunner in the Marine Corps. At least one of the witnesses at the trial was an informant for the FBI, according to the document cited in the motion. One document dated February 25th, 1965, said the Bureau had ordered its local offices not to disclose to the New York police the fact that any witnesses were federal informants. Okay, so talks more about prosecutorial misconduct here. The prosecutors were aware that undercover detectives were present at the time of the assassination. The motion says, adding, the people did not call any undercover officers at trial. There is no record of this information having been disclosed to the defendants. Because potentially exculpatory evidence never reached the defense, the reinvestigation concluded that Mr. Aziz and Mr. Islam did not receive a fair trial. Mr. Vance, that's the Manhattan district attorney, was asked on Wednesday if he personally believed that the two men were innocent. Innocence is actually a term he won't find in the penal law. He said, I will say this, the vacation of these convictions, and the dismissal of the indictment means that they stand like any other person who has not been charged with a crime. They stand as presumed innocent. Okay, and there's a picture of 3 of Malcolm X's daughters. And they say they hope the full truth can come to light. Okay, so I guess it has been almost an hour again. I was always hoping to keep these things short and sweet, but there's always just so much to say. Eventually, I do hope to maybe have a live stream about the Ahmaud Arbery case, knowing that next week is Thanksgiving, so a lot of people are going to be out and about and traveling. Stay safe and everything. Thank you guys for joining in today's live stream. Take care.